I suppose I'm here in a personal capacity, but I'm here as somebody who actually sees the consequences of the failure to have an amendment over a long period of time. And like many others, I think the Minister deserves sincere congratulations as being the person who has finally brought this amendment to the people. Or whatever way this goes, I think that in itself is a major achievement. On the whole area of state failure, when the state will intervene, the focus of the proposal is going to be very clearly on looking at the effect of the actions of the parents rather than the reason for the failure. I think that's hugely important, and is one I think that will result in much better outcomes for children. Because the way the child protection system works at the moment is that there is an overemphasis on the parental failure rather than on the effects on the child. And we have two very different child protection regimes. And what this referendum says very clearly is that regardless of the marital status of the parents, is that the state will actually be in a position to assist a child where that child's safety or welfare is likely to be seriously prejudiced. I come then to the area of adoption. And the area of adoption is an area I'm very familiar with. And over the last 2 decades, what we've seen is hundreds of children now being placed in long-term foster care. And those children have not been in a position to be adopted. Now, if I can explain to you really what the test is at the moment, and you don't need to be a senior counsellor to determine that there's a difficulty, because the Adoption Act of 1988, which was updated in 2010, permits adoptions for children in long-term foster care where there's been a failure in the duty towards the child for physical or moral reasons for the previous 12 months. So just keep that in mind. The next link to that test is that that failure is likely to continue without interruption until the child reaches 18 years of age. Then you have to prove that there has been an abandonment by the parents of all constitutional rights. Now think of that. Failure, physical moral duty for the previous 12 months. The failure is likely to continue without interruption until the child reaches 18 years of age, and an abandonment on the part of the parents of all constitutional rights. Can you now understand why it's very difficult to adopt a child in long-term foster care? That test makes it virtually impossible in the vast majority of cases, particularly for children of marriage, for adoption to be even on the table for consideration. And what I see week in, week out is children arriving before the adoption authority at the cusp of adulthood. 17 and a half are rushed to the High Court to see whether an adoption order can be granted. Why is that? Because the HSC are concerned that if they allow a child to be placed for adoption in long-term foster care, that test will not be proven, and the failure will continue without interruption until the child reaches 18 years of age. So what you have then is you have a large number of children, over 2,000 children in long-term foster care, who drift from one foster care placement to the next and are not eligible for adoption. For a significant number of children in long-term foster care, rehabilitation with their biological marital family unit is an unattainable goal. These children, although they no longer have access with their biological marital parents, nevertheless are not legally eligible for adoption. They can only be adopted if it can be proven that the marital parents have failed in such a manner as to be proven that they have abandoned all rights. In other words, the marital parents have to be proven as legal failures before children can be adopted. Of necessity then, these 2,000 children potentially, are locked in this twilight zone between a family that fully cannot care for them and a family that cannot fully adopt them. In my view, the basic human right, as a right of a child, that child at least should be considered to be eligible for adoption. So it's about giving these children a second chance, to remove them from the twilight zone, to give them that right to the stability and security that follows the granting of an adoption order. And what I feel is quite ironic, at the time of the divorce referendum, we talked about giving parents a second chance. This is about giving children a second chance to enjoy the stability and security of a caring and loving family. And that's why I think, if for no other reason, that it's worthwhile going out to vote for this proposal on the 10th of November. And what is proposed? It's a very measured proposal, because the Minister, much to her credit, along with the referendum proposal, published draft legislation to give us all an idea as to what legislation she will introduce if this referendum is successful. What she's proposing is she's suggesting that there must be a position where a child's been in care for a period of 3 years. The child must be with the prospective adoptive parents, in other words, the foster parents, for at least 18 months. And what you will require to prove in that case is you've got to prove an abandonment by the parents of all constitutional rights for that 3-year period. So this isn't going to happen overnight. It's going to be a very measured proposal. 3 years, 18 months with the foster parents, and then you've got to prove that there's been an abandonment on the part of the parents of all constitutional rights. It then comes to the adoption authority. The adoption authority will consider whether it would be appropriate. Because some kids, it may not be appropriate to place a child for adoption. And then it goes to the High Court, and the High Court is the ultimate check. But what's very positive about the legislation published is that the ultimate deciding factor will be the best interest of the child. I think that's what we all want. And in my view, this referendum, and I'll finish up on this, is that for many children and families, the state has failed them. And this is a new beginning. It's also an acknowledgement of those for whom this referendum comes too late. And that's why I think you have a real opportunity. But just very briefly before I finish, just on the other proposals where it might make a difference. The best interests of children should be a paramount consideration. I think that's a step forward. Because what this referendum proposal, if you can imagine, really what it says is that the opening statement is a general statement of values, that we recognise the natural and imprescriptible rights of children, and the state will ensure that those rights are protected and vindicated. So there are constitutional obligations to make sure that the rights of children are protected. And then there are a number of requirements on the part of the state to introduce legislation. Legislation in respect of adoption. Legislation to ensure that the best interests of the child are at the centre of the decision making. And what's important about this is that the Constitution will require the state to make provision by law for the best interests of the child. There will be a constitutional obligation to provide for the voice of the child by law. And if there is one legacy from all of these reports, is that we should listen to children. I think that's hugely important. And coming back to an issue that both the Minister touched on and Olivia touched on, the issue, hugely important issue, will this trample on the rights of parents? Anybody that tells you that it will is not painting an accurate picture, because this referendum proposal does not alter the provisions dealing with family, Article 41 and 42. So the amendment does not alter the family provisions. The presumption that the welfare of the child is to be found within the constitutional family will continue to apply. And one thing the Supreme Court has been consistent on and has expressed in expansive and clear terms is the paramountcy of the family, and that won't alter post the referendum proposal. Finish by saying that having spent a summer looking at the case histories of children who died in state care, you're left with the conclusion that we can do better. I think what this referendum proposal does is refocuses the child protection system to the child. Because for me, I was left with the heart-wrenching conclusion that for some children, the outcome could have been different. The report really gave me a unique window into the system where not only did the state fail these children, but also their parents failed these children. These children were allowed to drift rudderless in the care system. What jumps out from the social work files is the invisibility of these children. My view is no child should be forced to be put in a situation that he or she is at risk to protect an institution. No child should be made to live a life of unspeakable neglect or abuse to protect his or her abusive parents. Ireland is a country that sees itself as child-loving, yet has failed to protect the rights of children adequately in its constitution. As I said at the outset, an entire generation of children has grown up since we first started debating this issue. Let us not let that situation continue. On the 10th of November, you have the opportunity to ensure that this generation of children will benefit from strong constitutional protection. Will we be in a position to say that we are a country that really does cherish all the children of the nation equally? Thank you very much.